Let's start our study. You can leave that. We gotta study. Let's start that. You could go. Yeah. Okay. Yeah. You could.
You turn this on?
Huh?
You turn this on?
No, this is no, it's off. This is oh, this is yours. I'm gonna okay, we're gonna oh, let's put this down there again. Okay, we're gonna start with okay, what do you got?
I just printed this off yesterday. This talks about a lady in my class referred me to this. It's basically she said
This one's mine. Which one's yours?
You can have these ones. The one.
I'm gonna turn this off because the phone will ring because people. That's alright. You always need me. Yeah, this one's yours, right?
No, this just talks about like, I guess everything, like what is everything is a pamphlet that talks about what is like authority or personal representation. She told me this will help me. She said,
oh, that's nice. That's the procedures. So this is one class, and it's all the whole thing is about estate. The whole.
It's one class.
Wow. Okay. So what did you do so far? What questions do you have so far?
The question I have. I don't necessarily have questions, but when I was at home, I'll be by myself, so I try okay, what was she? I just try to think of questions that she would ask from previous tests. I looked at previous tests. So what I did, I was like, some she might be like, what's examples of property of state? So I didn't note cards examples. I wrote a couple examples.
So what are they?
Property of the state. It's in here, but I believe it says something like property of the state is when someone dies, like the person, if they die intestate, which is without a will or with a will, the person, the executor or administrator will go through and check their account, whatever, see if they die with the will or not. Go through and see. They will fill out all this.
But you said what is the property of the estate?
Yeah.
So
I'm saying like the property estate, like what is it like?
Well, wouldn't it be for the way I'm listening to it is what are the items?
These are examples.
Okay, so I think that would be the answers.
Yeah, these are examples of property estate, but I thought you was asking like what is property of the estate?
Okay, so that's two different questions.
Right.
So okay, so you have what is, and then give me examples.
Right.
But I think she'd probably be asking you to give her the examples. So give me the examples. What are they?
Yeah, household vehicles is like I think it's miscellaneous, like such as watches, TVs, stuff like that. Life insurance.
Right, stocks.
Yeah.
Bonds.
So I know a couple of them.
Yeah, so if you know all of these, then that should be it. Because I think that's what I would be, but what I would do to cover both bases, I would give the definition of it and give you the examples.
Yeah.
That way.
Okay.
Yeah. Okay, what other question? She's just talking. It's allergies. I'll get that.
Okay. You said
give me the other one here. Give me an example of, like what you would do is it's good to ask questions. Like if a statement is written, then you ask it in a question. Then you'll always remember the statement.
So you saying like make a regular statement
like this is a statement. What is this?
Joint accounts with right of survivorship.
Okay, so the question reverse is what is right of survivorships are joint account.
Yeah.
Joint account and
they say list banks accounts, each account number balance, joint owners. That's what it says.
Okay, and then same thing with this, stocks and bonds. So this is properties which can be added to the estate, right? But all you do is just put this on your
face,
right, and it'll pull it out instead of you because when you
touch it,
push it in, it goes deeper in. Believe it or not, it goes down deeper instead of coming out. The oil come out. So just put this on.
You seen me?
Yeah, you keep on doing it. It'll just pull it out. Right, it'll just pull it out, and you just have to don't touch your face. And it'll just, if you're allergic to it, you'll know in a minute. It'll know by tomorrow. Like my mom, the vitamin E was on to yesterday, and now it's just too strong. So we stopped doing our vitamin E. Your skin is too sensitive. Okay, now the next thing. So property of it for estate this is just a pamphlet that the lady gave you to read again.
No, that's what I printed off. Okay. Because it basically, I guess it defines everything. Like as I was reading it earlier, it was like it was telling me like what does the probate of letters. Let me see, I think it's up here. What does the probate of letters do? And all that. It say when the person has died, a search should be made to see that the person, the decedent, left a will. If there is a will, the clerk of Superior Court, upon application and probating letters, which is this paper, it issues, basically telling what this paper does, it issues letters to the person who qualifies as executor of the will. Letters testamentary are the official written authorization for a person to carry responsibility of executor of a will.
Awesome.
So I mean, it did help me.
But suppose somebody didn't file it in the county, now that makes it a problem. Because they didn't file it. See, this is like when you look for this stuff, people actually went down to the court. They fill out this thing and they file their will. Right. But some people, like, we've never filed a will. We have it, but we just haven't. So they would have a problem. But the person that, when the person passed away, they have to show for it they have a will, So it's really good to file it, but then you're putting all your personal business out there for the world to see as well, which is no good nowadays, right? And people duplicating people. So, okay. I'm going too deep. I want to try and keep it basic. Okay, next question that you think she may ask. Okay, what's a bond?
In my understanding, someone incarcerated, they pay a bond. Is that?
Well, it says generally an executor or of a will. Well, see, a bond for incarceration is money to get a person out. But this one is bond. Let's see what this says. Executor of a will who is a North Carolina resident and requires to furnish a bond before being authorized to act as executor. So they got to put up some money unless the will exactly requests that bond be furnished. However, there are exceptions, and the clerk of Superior Court always has a discretion to require a bond. An administrator of an estate is required to furnish a bond unless all the heirs, you can have that, heirs of, because they'll help with everything else. 18 of age or older, to sound mind, and have file written waiver. Waivers of personal responsibility bond of the bond requirement. However, no bond is required of an administrator if the administrator is the sole heir. Oh, that's really good. Thank you, Jesus. You know what I mean? You have to pay money to, oh my God. If the sole purpose of the appointment is to bring a wrongful debt lawsuit, a bond is not required until immediately prior to the receipt of the wrongful debt fund. Wow. Bond is required and cannot be waived when an administrator is not a North Carolina resident. Wow. That's a lot of good information. So a bond is money. You still, just like you said with the someone being incarcerated, the court assess a bond so that they can be free or not, right? Or, whatever, or to get them out of incarceration. But it's also for, in a will, the person who's going to take care of it is also got to put money up too. I guess that protects from anyone coming to the table saying, well, I'm the rightful. So when money has to be put down, people are like, I don't want to pay that. So, but also in a will, you can also tell the will, in your will, who is your executor too. But it's saying that they're going to have to pay. An executor of a will who is a North Carolina resident is not required to furnish a bond. Thank you, Jesus. Oh my God. But if you're not a resident, if you don't live in North Carolina, you are required. And then, right, and then also an heir no bond is required for the administrator if the administrator is a sole heir, like an only child to that. So that's really good. Thank you, Jesus. My God. All right. I'm talking about for me. Like, I gotta put up a what? Okay. All right. So we got what a bond is, and what else is there? Property which can be added. Other properties.
Also, it's right here.
Real estate is in the will. Deceased, real estate owned by the decedents and spouse. And then what else? What else were you gonna say?
Well, this preliminary inventory. These are instructions. It's like part one. When you see part one, you see how it says in the sole of account of decedent or something like that. It says for each account, list the name of the institution. So you list either bank. Let's see how listed that. Then the account number,
right.
But we can get that, and the balance on the date of death. Basically, it's like telling you all what everything of this is, while this paper says like what each section is.
Right, and each section breaks down the subsection, right? Because this one is property of this state, property which can be added. Are right of survivorship, bank accounts and balances, and joint accounts, stocks, bonds, securities, registered in beneficiaries form and immediate transfer on a debt or jointly owned with right of survivorship. It's like a spouse also, or somebody divorced also can be getting money because they live with them a certain, like a military person.
Right.
They marry somebody for 10 years, then they can go and claim the right of survivorship because they were their spouse. They can get that money. Other properties, personal recoverable cars, real estate owned by descendants and not listed elsewhere. Part 3 is other properties. We said real estate already. Insurance, because some people have life insurance that pays out. Retirement plans, IRAs, which is the Internal Revenue. It's money that you put aside, and when you get to a certain age, you can take it out, and it grows interest, and you don't have to pay taxes on it while it's in the bank. But when you pull it out, they have to pay taxes on it. Annuities, same thing, which is money saved up. The dividends that's coming, payable into the name of the beneficiary. What else?
And they say part 3 indicates certain property rights and claims which are not administered by the personal representative as part of the decedent's estate, in which the personal representative cannot generally recover to pay debts of the decedent or claims against the estate. Yeah.
And then somebody got to swear on it, and it's got to be notarized. Notary is best, but if you don't have a notary, 2 witness, 3 witness, what do you call them? Attestates, attesters, testify that they saw the person sign the document. Well, that's good. Okay. Any other concern? What is that one? That's the inventory. That's the same thing.
Inventory for the decedent's estate.
Oh, that's a different thing.
Yeah, but when me and this one girl from our class, we was going over. Basically, she said the paper will tell you, but they have more experience with this than me. So this is all new to me. So I'm slowly but surely learning. But you can just fill out the same information.
Right.
Sometimes they might reword it or something. But
right. It's the same. It's just repeated in another way.
Yeah.
Because it goes in different piles. That's probably what it is. When they get it. And kill him. Yuck. Debt of an ant. Okay. I don't even know how you get on the thing. It's like it dropped off the ceiling or something. The house is weird. Because it wasn't rocking around anywhere. I think it just fell off the ceiling. All right, next one. This one, the state of North Carolina, notice to the beneficiary. That's what you were talking about before. You were saying they would get...
the person he left the surviving person.
Mm-hmm.
So I believe they would just, whoever is on the will or will just fill this in or whatever. I'm assuming.
The courts, if there's a probate, whoever is the administrator or the executor would fill this out, and the notice goes from the courts to the person who's the beneficiary, because the beneficiary may be in different states, so that's why they have to have their name, phone number, and address if known, and stuff like that. If they can't find a beneficiary, the state keeps the money.
And
the state keeps
I
everything.
believe it's called, is it the law of intestate succession?
I'm not sure what it's, but it's the state can keep everything if there's nobody.
Because intestate means without a will, so in that case.
Where's the dictionary? Do we have that today?
No, I don't have with me, but I have the notes.
Okay. Yeah, this one is the easy one. Notice notice. Take note that the last will and testament of a descendant of a.
When I get home, I'm on Blackboard and see if she uploaded anything. She never texted me back, so.
The last will and testament of a descendant's name above, of which you are a beneficiary, will admit to probate in this office. The address, title, and phone numbers of the fiduciary who qualify is set out below. So the fiduciary is the attorney or the administrator or the executor. We talked about that last time. Okay, and their phone number so they can call them. Deputy Assistant Clerk of Court. Great. Okay, so we got that one. That one is easy.
Okay.
This one, and I'll show you. I was gonna go and get my husband's because, I was pull his arms to. I need that will because what happens. The will and the will is great, but the thing that's even more powerful is the medical proxy, the medical power of attorney, because that tells the medical community how to care for that person. Without that, the will doesn't. The will kind of like ends when the person dies, and but if the person is alive, there's nothing to tell them what they can do. So the person got to also do a will as well as medical power of attorney. You got to do. That's kind of while alive. What is it called? Oh goodness. A DRA, a directions, what should a person do? And if they cannot speak or can't do for themselves, it gives directions, it's a medical proxy. And so the person who is responsible can address all the medical concerns for the person while they're surviving. But I'm just letting you know, because a will is great, it's very powerful, it takes care of property, real estate, assets, the Bible. The person have a Bible, why I have so many Bibles, because I have all these sons, and so nobody will fight. They'll be able to get one, because they're like, that was mom's, So I'm just saying that's really, for me, that would be a big deal, For my mom, I got her Bible. I'm using it now. I don't have anybody to fight with because I'm the only one, right? But when you have more than one siblings, like you have 4?
3. I'm the youngest out of 3.
Oh, out of 3. There's not 4 of you guys? Okay,
yeah,
so
4 of us.
Yeah, so so there's 4 of you. So you're the youngest out of 4. Okay. Youngest
19,
out of 4.
20, 25, 4 and 25.
Yeah, youngest out of 4, not 3. You said youngest out of 3. I'm like,
I'm gonna say 4.
Okay. But you guys are gonna fight over mom and dad. If they don't have a will and they don't have a medical power of attorney, they gotta have it. So it's really urgent to get it done. Even when you just, like, I'm getting ready to have a child, and I'm gonna be a guardian of the child. Well, I have the last will and testament in that document, and all the medical power. If she gets pregnant, child ain't even 4. Okay, but you just never know. They may say, okay, Bishop, we need you to take care of our child for a week or a month, but that may end up being a year, 2 years, 10 years, a life. So I got it as perpetual. So if anything happens, they can come back, get their child. If they never come back, we have everything already documented and crossed, and everything signed by mother, father, grandmother, and grandfather. That's how I go down deep, because I want to make sure that everybody, and notarize, and then given to their attorney to make sure that child I can really take care of. Because if there's anything missing, you can't do anything. Right. You can't take care of the child medically. You can't do anything. I mean, it's just really, really amazing. So these paperwork are so important. Okay, so the next page, I'm going to go through this. We're almost finished. You're doing good. You're doing good.
I hope I do good tomorrow.
You're going to do great. Authority of a personal representative. Authority of a personal representative. What is that? The authority of a personal representative is an authority to collect assets, pay claim, and make all disbursement necessary to settle an estate. I was telling you about the estates that I've received since I've been here. I get people just give me, because we're a church, but so they entrust me with all their stuff. And I'm like, oh my God. So I have to literally be responsible for whatever, to fight and to win on the behalf of somebody else. And I take on those challenges. And, I'm not the victim, or I'm not they call them a B word, but no, I'm responsible for someone else's stuff, and they've given it to me. They've given it over to me or to the church. So it's the church name, my name, to care for their stuff. And they pass away, or even if they're alive, I'm responsible for that bad boy. Yep. So I am like anal about it, even more than my own stuff. It's amazing, So that's what a personal authority representative. Personal representative is authority to collect assets, to pay claims, to make all disbursements necessary to settle an estate, and to disperse the assets in an orderly, accurate, and timely manner. But the personal representative can sell any real estate of the descendant. So the property over there, I can sell it if I want to. I can sell this one if I want to. Whatever people have turned over to me. I got a 200-acre farm. That one I got in North Carolina. I can sell it at will, right? But I got property in Orange County. I got property in all over North Carolina. 7 Lakes, there. So all these things people have just turned over to me. Why? Because they just couldn't handle it anymore, and I'm like, okay, so I can't handle it. So anyway, so you have the power to sell the property of the decedents, or even when they're alive. But since you're dealing with will, we're talking about somebody that's passed. To generate cash with which to pay the debt of the estate. Sometimes people have left bills, student loans, all kind of stuff that they never paid or got to, because they just say forget about it, So you could sell the property and get hopefully enough money from that real estate to then pay off all the bills. If you don't pay off all the bills, you then become responsible to pay those bills off, because you signed that you take care of it, right? So the personal responsible representative must petition the clerk of the Superior Court for permission to sell such real estate. However, the clerk's approval is not needed if the will expressly directs the executor to sell the real estate property. So that's awesome. So you don't need the court always up in your business. But if you don't have anything stated, so everything has to be stated. In a will, everything has to be stated, and then it's good. You could do one personal, one-on-one, or you can do it with an attorney. But whatever you do, everything got to be in there. Okay, so this one is here. This one is for the books. Now what we got? This one here?
Affidavit notice to creditors.
Okay, that's the same thing. So the creditors have a certain amount of time that they can collect. If they don't get the notice and stuff, too bad, too sad. But okay, the second note, the second option should be checked only in cases where the descendant has no outstanding debts. I have debts of $280,000. That included tax and all of that. When I got here in 2008, I had no debts. When I got all this real estate, I got debts of the yang overnight. It was like, ah. So if something should happen to me, that's $280,000 got to be taken care of. It's got to be squared away. And so all this real estate, sell it, get the money, pay the bills, and then you keep the rest. So that's similar. my mom has no debts. She really was very, very particular with her money and everything, and she kept, her little change purse and everything. She never borrowed from anybody, so she has no debts. She has lots of land, lots of real estate. She owns property all over, and that's probably why I got the habit of buying property too, or gathering property. Our family always had land. We always been landowners, historically we owned everything. But because we own stuff, you got to do stuff like this. You have to do stuff like that. If you don't own anything, nobody nobody go to the funeral, everybody cry and woo-hoo, okay, goodbye, and then that's it. But a person that own assets, oh my God, we got the TV, we have radio. These are assets of intangible value, but it has a value to it or something, So it gets even deeper. If they have a business, everything got to be in this will. Okay, so if the business had debt or the person had debt, all the creditors have to be notified. That's what this thing is saying, right? So the same thing would be filled out. The county and state. Oh, your driver's license.
It's in the car.
No, you did not do that. No, you had to keep that with you.
Yeah, it's in the car though.
But suppose someone take the car. You have to go and find it. No, stop doing that. Bring that, carry that with you at all times. Really,
but I really carry a purse, but my purse, I don't carry my purse because people crazy. Like somebody might run by, snatch my bag or something, and I have money in it, so and it probably be like hundreds of dollars. So I try not to carry it. So that's instead of me carrying my purse, I usually just leave my license in the car. Just because I do this, I want to go. My purse at the house or something like that, or I put it in the trunk. And then, but yeah.
Okay. The second option should be checked only in case of the descendants has no outstanding debts. That will be me soon. We're going to be totally debt free in Jesus' name. Or the personal representative has paid in full all known debts. First option should be checked if all, in all other cases. So these are basically laws, codes, and the general statutes, the number, a section, chapter, as we looked up 14. Reasonable effort to, I made a reasonable effort to assess all persons. So the person that's responsible can only do but so much, whatever's in the public record on their credit report. If nothing's on the credit report, you don't know that the person owed you anything. So if the person that they literally owed something to, they handshake and everything, it was a long time relationship, they gotta, if they find out that that person has passed away, they gotta show up. They gotta show up and say, hey, that person owed me money, and they had to show proof of something signed, notarized preferably, but even a signed thing, word of mouth. Oh my gosh, it's good, but and strong oral promises, but it's hard to prove, So it's written. You always have to have something written, and they have to show up to get any money from the probate. Okay, so basically, let's see. So I made a reasonable effort to ascertain all persons, firm, and corporations. So that's businesses, right? Including the Department of Health and Human Resources. Sometimes people owe money, like when people get incarcerated and stuff, and their children, they have children, so the children are getting money by the state. So when the person come out of incarceration, then the person has a debt to the state. They got to pay back. The mother of the child or whatever, if it was a lady, vice versa. So if that was a case, they have to be notified if there's money owed to them, or the federal government, the Division of Medical Assistance, and if they have medical bills and stuff like that. If at the time of the descendant's death, the descendants was receiving Medicare, Medicaid, having unsatisfied claims against the descendants, and personal delivery of mail, a copy of the notice of creditors to all such persons, firms, and corporations then known to me, except for those claimed that I recognize as